0.306 Clarence's counsel, starting with the prosecutor.
Courtney Lawrence on behalf of the people.
Joseph Campbell on behalf of Mr. Smith.
All right. And counsel, it says we are here for a plea and sentence, so I assume we've got a resolution.
We do. It's my understanding that we're going to be charged, and the people have agreed not to offend the driving while license suspended to a second offense.
Mr. Campbell, is that your understanding of the plea agreement?
Yes, Your Honor.
Mr. Smith, have you heard what the attorneys have said the resolution is?
Yes, sir.
And is that how you wish to resolve it?
Yes, sir.
Will you please raise your right hand? You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? All right. So it's my understanding that you'll be pleading guilty as charged to driving a license suspended, revoked, or denied. That is a misdemeanor punishable by a fine of not more than $500 and up to 93 days in jail. In exchange for that agreement, in exchange for that plea, the prosecutor is agreeing that they're not going to seek to amend the complaint to add a second subsequent offense, which would make that 93-day misdemeanor punishable by up to a year. Is that your understanding of the agreement? Back on December 9th, were you on probation or parole?
Yes, sir.
Have the department taken any action in regards to this?
My probation officer said that he wasn't, I forget what he called it, but he said something about he was gonna break off on it.
Okay. Were you on bond in any other file?
No, sir.
I don't see an advice of rights form. Do you remember reading an advice of rights form? Talk about your rights to a trial and your rights to an attorney?
Yes, sir.
Did you understand those rights?
Yes, sir.
Most importantly, do you understand that you have the right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind? Other than the agreement, has anybody promised you anything in order to get you to plea? Has anybody threatened you in any way? And is it your own free choice to plea today? Are counsel aware of any other promises, threats, or inducements not made part of the record?
No.
Then Mr. Smith, to the allegation that on or about December 9th, 2025 in the city of Cadillac of Wexford County, how do you plead to count number 1 of driving while your license was suspended, denied, or revoked? In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on December 9th, were you here in the city of Cadillac? And were you operating a motor vehicle?
Yes, sir.
And at the time that you were operating that vehicle, had your license been suspended, denied, or revoked?
Yes, sir.
And did you know that it had been?
Yes, sir.
All right. Does counsel believe the defendants provided the factual basis to accept the plea and that the court rules have been complied with?
Yes.
Yes.
As does the court, I find the plea is knowing, voluntary, and accurate. Mr. Smith, I find you guilty of driving while your license was suspended, denied, or revoked. Are we able to sentence today?
Yes.
Yes.
Allocution?
Your Honor, Mr. Smith knows what he did was wrong. He's just begun to, I believe you got a job with your brother. He's trying to get some work and be a productive member of society. He would just ask to not spend any time in jail. He's happy to spend, pay the fines and costs that the court orders, but he is getting on his feet with this new job prospect and would like to stay out of jail.
All right. Ms. Lawrence,
Would waive allocution, Your Honor.
what brought him to the attention of law enforcement?
Looks like it was an expired registration tab.
Mr. Smith, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
Just as my attorney was saying here, Honor, I'm starting to get my feet on the ground and just ask for.
How long, how much longer do you have on probation?
To be honest, if I had the money to pay off my fines, I could get off.
All right. So you've not had any violations or anything like that?
Well, I had one shortly after I got out of rehab.
Okay.
And that's it.
How long ago was that?
Got out in January. I want to say it was around March, April.
You've been on probation for about a year, right? And so what was going on this day? Why were you driving?
To be honest with you, I come in town to get broken. I say that's how I eat.
Do you know what you have to do in order to get your license back?
I don't think I can ever get my license back.
And am I correct that your last conviction for this driving while license suspended was back in 23?
I believe so.
All right. All right, I will keep this to a fines and costs situation only. There will be a $75 crime victims' rights fund fee, $50 state minimum fee. $200 fine, $150 court costs. You're retained, correct?
Through the MIDC.
Oh, through the MIDC, okay. $150 attorney fee. There's no jail on this one, right? All right, 0 days jail with 0 days credit. Mr. Smith, any balance that remains owing after 56 days will have a 20% penalty added to that. You can go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able to. If not, get set up on a payment plan. And I know you currently owe us about $990 going back to 22 with no payments on that. Are you able to commit to any type of I mean, that could be $5 a month. I don't care.
Honestly, right, I mean, I can, just, it's a little tight trying to get off probation.
Is your address still M42?
Yes.
All right, so what I'm gonna do is I'm going to set you up on a financial review hearing. I'm gonna set that out for 3 months. So I'm gonna give you some time to get your feet under you and see what's going on with probation. But what a financial review hearing is where I bring you in, we talk about whether or not you're still able to get on a payment plan. If you are, we'll get you set up with it. We can also do wage assignments. So if you get a steady paycheck rolling in, you can assign an assignment that will have your employer take a certain amount out of your paycheck. All right. So go out to the front window where you checked in, get that judgment, get signed up. They'll give you the date for that financial review hearing as well. All right. Good luck.
Thank you, Ron.
Thank you. This is case number 25-5023 SD, appearances counsel.
Nate Carnes on behalf of the people. And I'm Jeff Harrison. I'm on behalf of Mr. Rupert. He's joining me at the table.
Counsel, the docket says we're here for a clean sentence, so I assume we've got a resolution.
I do indeed.
Yes, Your Honor, it's my understanding the defendant is pleading guilty to count 1, operating with a high BAC, and the people will dismiss count 2.
Mr. Harrison?
That's commensurate with my understanding.
Mr. Rupert, have you heard what the attorneys have said the resolution of this case is?
Yes, sir.
And is that how you wish to resolve it?
Yes, sir.
Will you please raise your right hand? You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
So it's my understanding that you'll be pleading to count number 1 of operating with a high BAC or bodily alcohol content. That is a misdemeanor punishable by up to 180 days in jail and or a fine of $200 to $700 and or 360 hours of community service, rehabilitative programs, vehicle mobilization is mandatory with a prior, and reimbursements for the cost of prosecution and other governmental expenses. In exchange for that, the people will be dismissing the operating while intoxicated. That is a 93-day misdemeanor. And fines and costs, I'm sorry, fines of up to 100 to 500, and the other penalties remain the same. Now, I want to make sure that you understand something because you're charged with 2 drunk driving offenses. So if you were to push this matter to trial, the prosecution would only be able to move forward on one of the charges, not both. Do you understand that? Does that have any impact on your decision to plead today?
No, sir.
Back on December 4th of last year, were you on probation or parole?
No, Your Honor.
Were you on bond? Do you remember reading and signing an advice of rights form? I talked about your rights to an attorney and your rights to a trial.
Yes, sir.
Did you understand those rights?
Yes.
Most importantly, do you understand that you have the right to have a jury trial? And that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind.
Yes, sir.
Other than the agreement, has anybody promised you anything? Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plead today?
Yes, Your Honor.
Are counsel aware of any other promises, threats, inducements not made part of the record?
No, Your Honor. I would, but I was unaware.
Then Mr. Rupert, to the allegation that on or about December 4th, 2025, in the city of Cadillac of Wexford County, how do you plead to count number one of operating with a high bodily alcohol content?
Guilty, your sir.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So were you operating a motor vehicle on December 4th here in the city of Cadillac?
Yes, Your Honor.
And prior to operating that vehicle, had you consumed alcohol?
Yes, sir.
What is it that you were drinking?
Beer.
All right, how much did you have?
8 to 10,
Over how long of a period of time?
4 or 5 hours.
All right. Mr. Carnes, are there chemical tests to support the plea?
Yes, Your Honor, intoxilizer came back at a 0.303 and 0.309. The people will stipulate 0.303.
Mr.
As
Anderson,
for the defense.
do counsel believe the defendants provided a factual basis in which to accept the plea and the court rules have been complied with?
Yes, Your Honor.
I do.
As does the court, I find the plea is knowing, voluntary, and accurate. Mr. Rupert, I find you guilty of operating with a high bodily alcohol content. Pursuant to the plea agreement, the operating while intoxicated will be dismissed at the time of sentencing. Counsel, I have a substance use assessment in my file. Do you both have a copy of that?
Yes, Your Honor.
Yes.
Do either of you have any corrections or additions to it?
No.
There you are.
Mr. Harrison, elocution?
I think the reason I was so forthright in my response to your question regarding potential changes to the substance use assessment is that I think it hits it head on, what's going on here. This is a young guy who is involved with the social consumption of alcohol, had a couple of small red flags, MIP type situations as a younger person. Didn't associate his level of alcohol consumption or the amount of times that he consumed alcohol to be evidence of a problem or a dependency on alcohol, and I don't think he truly has a dependency on alcohol. It kind of shows us, and I mean the royal us, all of us, that even a little tiny anomaly in your drinking, your relationship with alcohol could blossom into something that you didn't even contemplate was there in terms of a mild substance use disorder. He was shocked by the number. He thought the tests were wrong. When he came back, he portrayed it to me as somebody told me it was 0.3. I just find that hard to believe, and so did I. When you talk to him, he comes across as, I'm sure he has in the court, polite, well-spoken young man, doesn't come across as someone with a problem. I think that's a good illustration for all of us as well. This is not something he worked to obtain. This is not something he, frankly, devoted a lot of thought of in the past, as it is. Perhaps in the prior situations where he was forced to go to the classes regarding the MIPs, I think it's easy, particularly in young men, for friends, family, other peer supports to fail to recognize any significant issue. And I don't mean to overplay my hand here. I don't think he has a significant issue. The concern is that he was able to get to 0.3 and drive a car, which would indicate, at least in my experience, someone who has a great deal of experience with alcohol. I don't believe he is that person. I believe he was naive enough to hang out with some friends, drink a few beers, and drive home without devoting too much thought to it. Those days are over. He will devote thought to situations like that in the future. He has vowed to me and his parents that he will never, ever do anything like this again, because this event has rattled him to his core. It's not only the usual stuff, right? You got to come to court, it's scary, you could go to jail, etc. But more fundamentally, he truly is has gained a deeper understanding that he needs to examine his relationship with old John Barleycorn. It's a situation that he fell into, and it's easy to see how, in particularly the young men as they're brought up, that doesn't give him any excuses or a way out. It's just sort of some background for the court in that regard. He is a good candidate for a period of supervision. I think he'll do well. I think he's relished the opportunity, frankly, to not have alcohol involved in his life at all, because then that gives him a chance to see what it's like not to have, you know, the kind of couple of beers here and there pattern that he had fallen into. I would encourage the court to place him on a period of supervision, despite the number, and I think that's part and parcel of why he's pleading to the higher offense, was that number is outrageous. The 0.3 number is what I'm talking about. This is a first offense of this type of thing. It is not his first offense involving alcohol. And I think that's solidly and well handled by the language in the substance use assessment. I think that's an accurate assessment of where he is mentally as well. Thank you.
Thank you, Mr. Carnes.
Thank you, Your Honor. This is concerning because of the blood alcohol level. The defendant was at the drive-through line at a McDonald's and rear-ended the car in front of him. So it's concerning that he was that impaired. But I do note here this note from community corrections that looks like he's been tested quite frequently and had no violations. So clearly he is taking this seriously. Given that, I think a period of supervision is appropriate. I'd ask the court to supervise the defendant for 12 months on probation. Thank you. And there are fees to law enforcement.
What time of day or night did this occur?
6 p.m., Your Honor.
And is there any restitution requested at all?
There is not. I'm not, just aside from the law enforcement and prosecutor fees now.
Right. Mr. Rupert, you had the right to address the court prior to sentencing. Is there anything you'd like me to know?
No, Your Honor.
Well, I have some questions for you. So what was going on? How do you get to a 0.3 and some change?
I honestly had no idea that I was that intoxicated. It's I guess a pattern of drinking that I got into that I didn't understand fully.
And this was on a Thursday, it looks like, at least during the week.
Yeah.
When I look at the legal status that was reported to the evaluator, you disclose the MIP and an open intox, but your record indicates that you had a disorderly drunk along with the MIP. Do you remember that disorderly drunk conviction?
Not necessarily.
Okay. And then your Secretary of State record also indicates that at the time of that open intox, that you had a careless and had been drinking during that event. Do you remember that?
Yes, they breath tested me and I drank after the event. I had to walk quite a ways with no phone service, and I stopped at a friend's house.
So, and it also says that you're contemplating getting your GED in the future. When's the future? You're what, 29 now?
Hopefully within the near future.
Are you still employed at the same place you were?
Yes, sir.
So I catch myself saying this quite a bit, and because these assessments, I have to say, kind of throw me for a loop from times. But I'm not an assessor, so I have to rely on what they come back with. But it baffles me how one can get to a 0.3 something, operate a motor vehicle. I don't know where you were coming from, but you at least had the ability to get from where you were coming from to where you were going, which happens to be McDonald's. Now, you did rear end somebody in the drive-through line, and yet the assessment comes back as having a mild disorder. Especially when I look at somebody who's got a history of a disorderly drunk, an MIP, an open intox. I understand you're saying you drank afterwards, but at least your Secretary of State record shows that at the time of the event you had been drinking. So that's what I've got to rely on. And so and to come back with a mild disorder. I don't know if Mr. Harrison or the assessor explained to you, but there's a few ways that you can come back with a disorder. One is not to have any issue at all. One is mild, and there's moderate and severe. So you're kind of at the bottom end of that, but to be able to function the way you did at a 0.3 is very, very, very troubling to the court. And I can also see that if you don't get turned around, it's not going to be very long before you're at that top level. Now, you've been on bond since the 5th of December, and I've had you doing daily testings. I've not had any violations. How are you finding that drinking?
As in, how am I handling not drinking?
Yeah.
I've had no issues so far.
How often are you testing?
Right now it's 3 PBTs a day.
Okay. So your assessment also kind of, a statement in there makes me tend to think that you also recognize that you may have had an issue. And that is that he, meaning you, disclosed prior to that date, he would drink alcohol on the weekends, sometimes beginning on a Thursday, and stated, in quotes, "I would try to give myself a few days break." He reports that he would normally consume probably 3 to 4 drinks, but on the night of the offense, you drank 3 to 4 beers and 3 to 4 shots of Fireball. And I realize that's different than what you told me during the plea, but I also realize you were at 0.3 and this was over a month ago. But the statement that you would try to give yourself a few days break also causes some concern. And also makes me, so there's a few things that I question. One, your level, that statement, the fact that there was a disorderly drunk and the careless, make me wonder whether or not the assessor had all the information she needed to get an accurate report. So for all those reasons, I think it's appropriate to put you on a period of probation. I'm not going to put you in jail, but I think probation is going to be beneficial for a few different reasons. One, we're going to educate you. We're going to make you attend the alcohol highway safety education class and the victim impact panel. We're also going to order that you do some sort of counseling for alcohol. All right. So during this period of time that you're on probation, which I'm going to put you on probation for 24 months. However, if you're doing everything that you need to do and you've been successful with it, you can be released at the halfway mark, which is 12 months. If you think you should be released at that point, but your probation officer doesn't, you can petition the court on your own to be released, and we'll have a hearing and I'll make that determination as to whether or not you should be released. But during the period of time that you are on probation, you're not to violate any law. Report is ordered, not leave the state without the consent of your probation officer. Keep your contact and employment information current. Again, I want you to do the alcohol highway safety education class, the victim impact panel, not to consume any alcohol, no illegal drugs, no recreational marijuana, and you'll be subject to testing pursuant to your probation officer. So you're done with the daily testings today. When you leave here, do you have that device with you?
I do not.
Okay. You're gonna want to return that to community corrections. I also want you to follow the substance use recommendations. Again, as I said, drug and alcohol counseling, along with any additional programming that your probation officer feels is appropriate. There is a $75 Crime Victims' Rights Fund fee, a $50 state minimum fee, $200 fine, $150 court costs, $150 attorney fee. I'm only going to charge you for the 12 months of probation, which is $360. If something happens that you end up staying longer than that 12 months, you'll be required to pay the $30 monthly probation fee. There is a $100 reimbursement fee to the prosecutor. And this is City of Cadillac, is that correct, Mr. Carnes?
That is correct, Your Honor.
And so $200 reimbursement to the City of Cadillac Police Department. In certain situations, law enforcement and the prosecutor are able to recoup a portion of the expense in prosecuting those cases, and that's what those two fees are. Anything else in a judgment of sentence, Mr. Carnes?
No, Your Honor, thank you.
Mr. Harrison?
I'm satisfied with the record. Thank you.
Mr. Rupert, there is 1 day jail with 1 day credit. Based on statute, he's entitled to a $5 credit for that, so $5 will come off your fine. Mr. Rupert, any balance that remains unpaid for more than 56 days will have a 20% penalty added to that. However, during the period of time that you're on probation, I'm going to waive that penalty. So as long as you get it paid off during your probationary period, you'll be good. Also, because I have sentenced you to a period of incarceration or jail, even though it's time served, you do have the right to appeal that decision. If you decided that you wanted to appeal it and could not afford an attorney to assist you, you have 14 days from today's date to request the appointment of an attorney. Do you understand all that?
Yes, Your Honor.
All right. All right, you can go out to the front window where you checked in, get your next court date, make a payment if you're able to. If not, get set up on a payment plan. Then you'll need to go downstairs to district court probation, which is kind of kitty corner from where community corrections is, and get signed up for your probation. And then again, you're going to want to get that machine turned into community corrections as soon as you can. All right. Best of luck. And hopefully we won't see you between now and the year, but if we do, hopefully it's out in the audience.
Thanks,
All right. Best of luck.